Hello and welcome to Dorsey and Whitney's Bank Counsel Roundtable on cryptocurrency and bank regulation. Current developments. I'd like to introduce Nick Vleetstra, a partner in Dorsey's Finance and Restructuring Group. Nick?
Thanks, Rima. Good afternoon, everyone. I'm Nick Vleetstra. Welcome to the September meeting of Dorsey and Whitney's Bank Counsel Roundtable, and thank you for joining us. We've planned a presentation on current developments with respect to cryptocurrency and bank regulation. Our speakers are Dorsey partners Aaron Bryan, Tom Gorman, and Joe Liniak, whom I'll introduce shortly. But first, a couple of housekeeping details to go over with you. Today's program is scheduled for 60 minutes, and the materials for the presentation, as well as the attendance form, are available for download through the reminder email that went out to registrants yesterday from events@dorsey.com. As was explained in that email, you should send your completed attendance form to attendance@dorsey.com, and then certificates of attendance will be sent to those who return that completed form. Today's PowerPoint deck is also accessible via a link that will be included in the survey email that we will send out to you tomorrow. Also note that we will not have Q&A during or after this presentation. If you have questions for our speakers, you are welcome to contact them directly or through your usual Dorsey contact. The speaker's contact information can be found in the presentation materials with their bios. Okay, with that out of the way, let me introduce today's three speakers. First, Aaron Bryan is a partner in the Finance and Restructuring Group at Dorsey and is co-chair of our Consumer Financial Services Group. Aaron is a member of the American Bar Association Banking Law Committee and vice chair of its subcommittee for bankruptcy and workouts. She is also on the board of the Turnaround Management Association's Minnesota chapter, and Aaron works out of Dorsey's Minneapolis office. Tom Gorman is a partner in Dorsey's Government Enforcement and Corporate Investigation Group. He defends clients in federal law enforcement investigations and enforcement actions brought by the DOJ, SEC, CFTC, and other government agencies. Tom is based in our Washington, D.C. and New York offices. And finally, Joe Liniak is a partner in the firm's Finance and Restructuring Group and is a nationally known bank regulatory lawyer practicing out of the firm's Washington, D.C. and Southern California offices. As I mentioned, additional biographical information for our three presenters is included at the end of your materials, as is their contact information. And with that, I'll hand you over to Joe Liniak. Thanks, Joe.
Well, thank you, Nick. Good afternoon, everyone. This is going to be a fun topic because everyone professes to know a little bit about crypto, but really doesn't understand how it works or what the risks are. And we're going to take the perspective, which is a little bit different from, hey, everybody should buy crypto, to focus in on how the government has reacted to the crypto ecosystems that have developed and how they have applied traditional legal theories, because this is a legal seminar, to what's been happening out there. And what are we going to look at here? We're going to look at crypto developments, including some of the losses, fraud, and failures that recently have occurred, talk about current laws that I just mentioned, such as SEC rules, FTC rules, bankruptcy rules, move on to the way the government has begun to finally respond in a cohesive manner to crypto with the issuance of an executive order by President Biden a few months ago with an emphasis on central bank digital currency, ending up with a few observations and conclusions. But let's start out with what's been going on in the crypto world. Many of the developments have happened within the last several months, most of which are actually pretty bad. First of all, crypto started out in April and May having about $2.5 trillion of value, and abracadabra, they've lost about half of it, actually more of it. It's now less than $1 trillion, 58% of which was due to the loss in valuations of Bitcoin. During one 30-minute period, Bitcoin lost 30% of its value. In addition, billions and billions of dollars of losses have occurred due to theft and fraud. What has happened is, you hear things such as, oh, well, the blockchain is invulnerable. It's like Superman. Well, that's not really true. There's a lot of weaknesses in blockchain. If you give somebody your wallet and your private keys, you're giving them the key to the kingdom. And scallywags have taken advantage of that and stolen things. Some of the exchanges, in order to avoid U.S. enforcement, have moved overseas. And enforcement has now begun to take place with federal regulators. There have been bankruptcy filings, which Aaron is going to talk about, which are really fascinating in terms of how those failures occurred. I will notice the fact that you've heard about, oh, well, hey, we fixed this because we've got stable coins. Well, stable coins are frankly not that stable. There's tax liability. The moment you decide to convert your crypto, you've got a tax liability, which people are saying, gee, that's not fair. But actually, that's the way the tax laws work. And then, naturally, there's lobbying now where crypto proponents are saying we need to fix all of these issues. But I will tell you that legislation is pretty far off. Now, crypto proponents are a bunch of crybabies. I mean, they're whining all the time that the rules should not apply to them. And they talk about we're engaged in regulatory incrementalism, meaning that the agencies are applying rules to them when they are a whole new thing that we have to worry about. Well, that's really not true. They're applying the rules that apply to a new asset class. And some of those rules are pretty clear. Also, they have avoided, in many cases, discussing protection for investors and consumers by the application of decades-old laws. And then finally, well, I wouldn't say that people have engaged in pump and dumps. There certainly have been, and you're probably all aware of this when you're watching TV over the last several months, many commercials where noted celebrities have said, gee, I may not know a lot about crypto, but it's a really good thing, and maybe you should invest very wisely now, and then we'll, because you're going to make a lot of money, and I'm a celebrity, so therefore, take my word for it. A few notable events, which are some of the failures of some of the crypto ecosystems, and this is something that Aaron is going to talk about in a few moments. Now, I want to give you my personal view about what is crypto and blockchain really. And it's my personal view, and you may have a different one. If you made a lot of money, good for you. But the primary rule for crypto investing is be the first in and be the first out. And the best analogy to past investment opportunities are the tulip craze in the 1600s, in which tulips went sky high and everyone was buying them, and then there was a collapse. For those of you that are as old as I am, the 1950s hula hoop craze, where everybody was using hula hoops, everybody was investing in hula hoops, and suddenly hula hoops collapsed. And then buying orange juice futures and hoping that there's going to be a disaster in some state that grows orange juice, and you can make a lot of money by investing in orange juice futures. Only cryptocurrency is orange juice futures without the orange juice. So you can take a look at that and determine whether, what these things really are. They're really actually, they're numbers in an algorithm. And again, you can make up your mind on that. How much regulation is really there? Well, actually, there's quite a bit, and it goes back now because crypto has been around for over a decade. And it has happened not only nationally, but also internationally. There are many foreign jurisdictions that have adopted crypto. 45 states have adopted laws, which are mostly fine-tuned laws to address particular aspects, but in some cases have said, hey, you want to do crypto mining? Come on down with us because we're going to make it easy for you. There have been some exceptions, such as the New York bit license, which means that a lot of people have stayed outside of New York City. Of New York State. In one somewhat anomalous thing, a crypto bank has been authorized under Montana law. We'll see how that goes. The AML laws and money transmitter laws really do apply in most cases. And a lot of proponents of crypto and participants don't like that at all because it takes a long time to get AML licenses and money transmitter licenses. But at the end of the day, very little has happened on the federal side to address these issues, except for the SEC and the CFTC. And with that, I'm going to turn it over to my colleague, Tom Gorman, who is going to trace through what's been going on with these two agencies vis-a-vis crypto and our friend, the blockchain. Tom.
Thank you, Joe. There really is, as Joe said, a whole host of regulators in Washington who are looking at crypto. Crypto came out a few years ago. It developed its own language very quickly, talking about blockchain, smart contracts, things like that, things that people never heard of. All the terminology was changed. They didn't have an offering circular to sell the stuff. They had a white paper, whatever that was. None of these terms were ever defined. But the point was, crypto was, as they said, quote, off the grid, unquote. Well, I don't know what off the grid means. If you go camping and get lost, maybe that's where they went, because that seems to be what happened. There was a whole group of these regulators that really started looking at this, SEC, CFTC, FinCEN, FERC, pick one, and there is one, and then some of the state regulators, and then Congress, and then they boiled back. But the real core to this, I'm going to sort of skip to the middle of the program and then come back for you. The real core to this is the SEC and the CFTC. They're the ones who really, they started slow, they started developing it, and then they developed what you usually hear people talk about. Oftentimes you will hear people say, well, this is a security. And the people who want to be off the grid will tell you, well, no, it's not a security. This is a coin. It couldn't be a security. Really? Think again. It really could be, because if you go back to 1946, where the Supreme Court decided the case, it's up on your screen, SEC versus H.W. Howey Company. This is like the seminal case on what constitutes a security, which a lot of people still don't understand. It's actually fairly straightforward. What the court said was, you've got to take a look at the economic reality of what's going on with these things. So when you look at the coin, people say, well, it's a coin. True enough. And then they hear, well, it's maybe not security tomorrow, but it's security today. And that's because the coin is not a security at all. The economic reality of a security is very straightforward. You put your money into an enterprise like Apple. So you give Apple some money, I give Apple some money, Joe gives Apple some money, everybody in this group gives Apple some money. What's Apple do with it? They throw it in the big bathtub, they mix it around, and it comes out looking like an iPhone. And that's when you're doing that, that intellectualism, if you will, is a security. The idea that all of your money is getting put together with everybody else's is the security. It's not the coin. It's not the bathtub we threw it in. It's none of those things. The SEC likes to talk about the ecosystem, which is what the entity's doing with your money, but that's just another word too. It's your money, my money, and everybody's money. And if the idea is we'll put it together and you and I will get a profit, like you hope you do when you buy Apple stock, that's called a security. And once you do that, the whole world starts to change, because then you've got registration obligations. If you want to sell the stuff, you've got to have broker dealers who can sell this stuff. You've got investment advisors who are looking at this stuff. You've got the Division of Trading and Markets at the SEC who's looking at all this stuff. The world changes, all because we're going to apply this decades-old system to these new, let's get off the grid and let's take a look at what this stuff really is. But go back to the beginning, and it's relatively simple. I'm going to skip through how some of this stuff evolved, because it gives you a better feeling for what's going on here. So crypto starts, like Joe said, probably 10 years ago. And then the question is, well, everybody's looking at it and going, wow, what is this stuff? And everybody in Washington takes a look at it, every regulator, Congress looks at it, there's pending legislation in Congress, there's pending rule writing before every one of these agencies, and they're trying to figure out what to do with it. And here's the problem. For example, if you put this stuff you give it to an investment advisor, they put it into a fund. The fund has to get valued every day. Crypto is so volatile and so erratic that if you try to value what it is at the end of the day, it can be almost impossible. The same thing happens with stock markets. So try to put it in an ETF. You've all heard of ETFs. They're just big conglomerations of different kinds of stocks, sometimes the same kinds of stock. At the end of the day, you got to come up with a price. At 4 o'clock, everybody wants to know, how much is that thing worth? Well, if you got crypto in there, you can't tell most of the time because, as Joe was indicating to you, the prices, they go up, they go down, they go sideways, they're all over the place. They've lost millions of dollars in value recently. Tomorrow, they could come back with millions of dollars in plus value. Who knows? You may as well go play crap at a Las Vegas casino because you can figure out the odds there easier than you can with crypto. And that's the problem the regulators like the SEC had. So they started looking at this stuff and trying to figure out, how are we going to do this stuff? And that's when they started going back, started looking at how this stuff works, and started studying the basics of the securities laws. And finally, they created a report from an investigation called the DAO report. And that report said, Howie, the Howie test, take a look at this stuff. Don't get lost in all the lingo about smart contracts and that sort of thing. Get lost in the idea that the economic reality here is this thing is really a security. And when it's a security, there's obligations. If you want to sell it, you can't use a white paper. The white paper doesn't tell you anything. It doesn't give any rights to investors. So you stick your money in there. There's no protections there for you. If you stick your money in there, there's nothing that really tells you exactly what they're going to do with it, or if they did, makes them actually keep doing that. You give it to Apple, you know you're going to get a white phone. You give it to these other guys, you may have gotten off the grid, but that's about all you're really going to find out. So you're not really accomplishing much of anything. With the trading platforms, same problems. Now, if you turn it into a security, it's going to have a price because the securities laws will require you to have a price, and you'll be able to figure out where you're going to go with this stuff. So as this has worked through the system over time, what you find is people taking positions, seeing where they think they're going to go. And for example, by 2021, the SEC was issuing exam alerts for investment advisors and for others so they could tell you, this is what we're going to look at. We're going to look at how this fits into the model of Howie. We're going to look at how this fits into the model of security. And Gary Gensler, who was then the chairman of the agency, took a position and said, well, eventually we're going to have some more legislation. But before we got to that, really, as they felt this along, why don't you hit the next slide, would you, Joe? They were doing litigation. Early on, Chairman Clayton, who was chairman long before Gary Gensler was, he took the position that this was up to the professionals, and he invoked what they called the theory of gatekeepers. Gatekeepers is a long-held theory of the SEC. It traces back to probably the earliest days of the enforcement division in the early 1970s. And it said market professionals, and I don't mean just brokers and dealers, I mean accountants, I mean lawyers, I mean any professional who was giving advice in this area. Clayton actually almost threatened them. I mean, he gave them a very stern lecture. He said, we don't want you cutting corners. We don't want you pushing the edge of the envelope here. We want you making sure that there are guardrails here, investor protections for people. And under the gatekeeper theory, if there aren't, I'm instructing the enforcement division to come and get you. And that's almost a quote from Chairman Clayton at the time. And that really started kicking this into where the next thing up was what I called before the DAO report, which got you to the Howey test, which got you to the economic reality of what was going on and what was being put together for all of these people. And it was the beginning of the protections. But as it continued to evolve, you can see some of the other revolutions of how this stuff was evolving as the SEC continued to litigate one case after another case after another case. But most of those cases were fraud cases. There were people who were selling the idea that you were going to get a blockchain, and it wasn't. They were telling you that you were going to get tokens that were worth some money, but they weren't. They were telling you that they were going to appreciate in value, except they didn't. Joe said at the beginning of the program, he said, well, I don't know if they brought a pump and dump case. They have brought pump and dump cases. They brought dozens of pump and dump market manipulation cases. They filed one here actually yesterday against supposedly some of these people who were going to get you off the grid, alleging that in fact it was just a total sham transaction. It's a case pending in the Southern District of New York. Fairly interesting case. It's called SEC versus hydrogen technology, and that is the kind of thing that you found if in fact you didn't have the SEC in there saying, no, that's a security. You can't lie to people like that. No, it's a security. You've got to tell people what's going on with this stuff. And yes, it is a security. And if you want to sell this stuff, you better be registered as a broker or a dealer, or we're going to come and get you. They've spent so much time with this recently that the Division of Enforcement just added 5 new positions that are dedicated to doing nothing except chasing around after all of these cases. So they're worth watching. The evolution from off the grid, and at first the SEC, frankly, if you look at their stuff, they didn't know what they were going to do with these things, to things like Dogecoins, for people who remember that. Dogecoin started as a joke one afternoon, and by about a month later, people were investing in this thing. Why you would invest in a joke is beyond me, but lots of people did, and Dogecoins are still around. But they start selling them like a security, and at least what you're going to know is that you're going to get the information about where your money's going, about what they're going to do with your money, and how it's going to protect you, and that the people selling them to you or buying them for you are market professionals, so that at least they have some idea of what's going on with some of this stuff. So a couple cases that you want to watch as you watch the evolution of this through the future. One is called SEC versus Ripple Labs. And this is probably one of the most hotly contested cases going on. Ripple Labs has this technology that they call XRP. It's not really very clear what it is. The purveyors of this stuff claim that XRP is sort of the next coming of something. They claim that it's going to facilitate international communications, international money movement, all sorts of things like that. Will it? I don't know. The SEC seems to think not. The SEC said, look, this is a security. Early on in the history of developing this stuff, your lawyers told you it was probably going to have to register it. You didn't, but you may have seen lots of stuff in the press about this. It's a very highly contested case because the lead lawyer for them is a partner of the big New York law firm, and her name is Mary Jo White. She's a former SEC chairman, and her first lieutenant on the case is the former director of the Division of Enforcement. So there's been umpteen articles about this case. They've been litigating this case tooth and nail for 2, maybe 3 years, and it looks like it's going to go on for 2 or 3 more years. But this may be the biggest battle that's going to take place in this particular area as to whether or not this is going to how the securities laws are actually going to apply. If I was betting on this, I'd bet on the commission. They usually do pretty well. XRP isn't any different than the rest of this stuff. Another case that you might want to watch, and this really sort of shows you how the evolution of all of this stuff has been going forward, is there's a case called SEC versus Wahle, WAHLE. Probably mispronounced that, but that's okay. This is the first insider trading case to be brought against involving a cryptocurrency. It's a fairly simple case, actually. People, when they filed it, there was a big outrage about how can you apply this stuff to crypto? Well, this is how you apply it. The firm here is really an exchange, and the exchange, when it adds something new, when it adds a new asset class to it, price goes up. So people started leaking that information and trading on it. That's no different than a company leaking that they're going to be in a merger and in fact trading on it. It's called inside information. So that's basically the securities side to this. If you look at the FTC side, it's basically got 2 other key elements that you should look at. One is, the question is this thing an asset such that we can say it's a commodity? Court in the Eastern District of New York in the McDonald case that's on file here said, yes, it is, and nobody's disputed it. The second question then is, what about the trading? Well, unfortunately, the CFTC has very little trading authority, unlike the SEC. All these exchanges self-certify, but the way it works is, what the CFTC did is very clever. They built guardrails around it. They wrote rules all the way around the trading so that you can't move this stuff without really telling people what's going on and showing them the movements. So they created out of this network essentially what the SEC did by going back to Howey. They created an infrastructure that protects people. So the future here really is the evolution of this, and you can see how the evolution is going, because in 2021, Gary Gensler, chairman of the SEC, said, we need Congress. In 2022, Mr. Gensler turned around and said, we're not going to have any legislation or rules for a long time.
Oh, hey, Tom. Tom, we're running out of time here, so why don't you go to your conclusion and then we'll go on to Aaron, okay?
Oh, that is my conclusion, unless you want me to do the ultimate conclusion to the slide. The ultimate conclusion to the slides is the regulators are putting out rules. The regulators have gotten together and figured this out. And I think that Gensler is exactly right. There's not going to be new legislation. There is existing legislation, and the CFTC is applying it. The SEC is applying it, and it should protect people going forward. So the off the grid is off.
Thank you. Complicated and yet applying traditional theories, and that's one of the messages today. And now we're going to talk about the scallywags sending these things into bankruptcy and for other reasons. And I'd like to introduce my colleague, Erin Bryan, who's going to walk us through those issues.
Great, thank you, Joe. Today, I'll be discussing bankruptcy and insolvency developments relating to cryptocurrency. The last few years have been a wild ride for the crypto industry at large, and the bankruptcy courts are finally getting a piece of the action. In 2020, a California-based cryptocurrency platform called Cred Inc., which had an estimated value of $80 million, filed a Chapter 11 petition in Delaware. Cred had provided business and retail credit to crypto investors. and offered products that allowed customers to earn a yield on over a dozen crypto and fiat currencies. From day one of the case, there was a lot of finger pointing about what caused the bankruptcy. However, because an examiner was later appointed by the court to investigate, we now know a lot more about the various causes than we did at the time. One undisputed major precipitating event was a flash crash in cryptocurrency trading value in March 2020, which was followed by a run-up in April and May 2020, leading to a liquidity crisis for the company. However, the bankruptcy examiner also faulted Cred's management for allegedly contributing to the company's financial distress. First, what the examiner called unsystemic, chaotic, and in some instances, non-existent diligence, accounting, and compliance functions. Second, that Cred allowed currency migration to non-Cred entities operating in mainland China without legal or practical capacity to repatriate capital on demand. And third, misallocation of important managerial and operating functions to an individual the examiner described as having, quote, an extremely worrisome past, including being a fugitive from the UK government relating to a conviction for illegal money transfers. The examiner's report is definitely worth a read for those interested in corporate compliance issues. It makes for a fascinating case study of the rapid decline of a company due to mismanagement and a culture that would seem to put quick profits well above sustainability. We'll return to the legal issues raised in that case when we get to the next slides, but let's continue with the recent developments. So the crypto markets entered a period of extreme volatility and losses from 2021 to present, including notable events like the collapse of Terra's UST stablecoin and its governance token Luna. Several significant crypto bankruptcies have emerged from the recent chaos. In May of this year, crypto lender Celsius had $12 billion in assets under management. In June, it paused all withdrawals and transfers due to what it called extreme market conditions. It would file bankruptcy a month later. Also in June, crypto broker Voyager Digital issued a payment default notice to Singapore-based Three Arrows Capital, a prominent crypto hedge fund, due to the fund's failure to make debt payments on a loan for over 15,000 Bitcoin, or approximately $324 million today, and $350 million worth of USDC, a stable coin. Three Arrows at one time had managed about $10 billion in assets. However, after a Virgin Islands court forced it into liquidation, it filed a Chapter 15 petition in New York. Shortly after the filing, lawyers for creditors alleged that the founders of the company could not be located and were not cooperating with the case. The founders briefly surfaced 2 weeks later to give an interview to Bloomberg. And when liquidators went to the former headquarters in Singapore, they found locked doors, outdated mail, and no sign of the founders. Shortly after the Three Arrows filing, Voyager announced it was temporarily suspending all trading, deposits, withdrawals, and loyalty awards, and then it filed Chapter 11 in New York a few days later. Next slide. Then, most recently, a Minnesota-based infrastructure provider of crypto mining filed Chapter 11 in Texas. The filing is believed to be the result of a combination of challenges, including rising energy costs, the ongoing crypto winter, and regulatory challenges in Texas that prevented the company from monetizing a new Bitcoin mining facility that included 40,000 mining machines. Daily news stories about layoffs, withdrawal activity, and continuing market headwinds suggests we may be seeing only the tip of the iceberg in terms of crypto-related bankruptcies. Next, please. Against that backdrop, let's examine the fundamental question that arises when a crypto exchange or crypto lender files bankruptcy. And that is this: who owns the cryptocurrency? Under Section 541A1 of the Bankruptcy Code, When a bankruptcy is filed, a bankruptcy estate comes into existence. That estate consists of all legal and equitable interests of the debtor in property at the time of the bankruptcy filing. In some of the recent crypto exchange bankruptcy filings, it came as a huge and unwelcome surprise to many individual crypto customers who held or loaned their crypto through these exchanges that what they considered to be their crypto holdings were actually part of the exchange's bankruptcy estate, and all they had was a general unsecured claim in the bankruptcy proceedings. As SEC Chair Gensler recently remarked, if the platform goes down, guess what? You just have a counterparty relationship with the platform. Get in line in bankruptcy court. And in the Celsius and Cred cases that I mentioned earlier, that's exactly what has happened. Under their contracts, most crypto customers effectively transferred their crypto to the exchanges in exchange for a right to payment. One of the potential exceptions to this general rule may be investors who actually did have formal custodial relationships with an exchange. In either case, however, the bankruptcy courts are likely to start by looking at the specific contractual language and applicable state law to determine whether the exchange had a legal or equitable interest in the assets on the petition date, and consequently, whether they are property of the estate. One additional question that this raises is whether the automatic stay, which protects the debtor and property of the estate, could be used to bar customers from exercising withdrawal rights during the pendency of a case. So far, the answer appears to be yes. This could leave customers waiting for years to receive any recovery as they wait in line for distributions. Next slide. Of course, secured creditors typically fare better in bankruptcy cases than unsecured creditors. So let's say you as a financial institution plan to take a security interest in a borrower's assets as collateral for a loan, and some or even most of the borrower's assets consist of cryptocurrency. How do you go about ensuring attachment and perfection? Attachment is no different than for other assets. Value must be given for the security interest. The debtor must have rights in the collateral or the power to transfer the collateral to the secured party, and the debtor must authenticate a security agreement. However, the clarity ends there. Under the current Article 9, arguments have been made that cryptocurrency, depending on the particular asset's unique characteristics, could be a general intangible, an investment asset, or even money. This is significant because general intangibles are perfected by filing a UCC-1 financing statement, while investment property can be perfected by filing a UCC-1, or even better, by control. The prudent course of action for a secured lender who wants to perfect against these types of assets is to file a UCC financing statement and obtain possession and control of the crypto assets. Possession and control can be accomplished by transferring the crypto assets to an offline cold wallet or using a custodian, among other options. Hopefully, this will change as states start to adopt Article 12, but it will take some time for that to work its way through the courts. Now, even assuming the secured lender has done everything correctly up until this point and has a valid perfected security interest in crypto assets at the time of the bankruptcy filing, there are other challenges that arise during the case. A bankruptcy case, of course, can last for years, but crypto values can fluctuate wildly minute to minute. If a secured creditor demands adequate protection against the diminution of collateral value during the case, how does the court determine how much protection is enough? This is the sort of issue that the courts will grapple with on a case-by-case basis as crypto bankruptcy filings increase. Next slide. The unpredictable fluctuation of cryptocurrency values poses challenges for liquidation as well. How does a Chapter 7 trustee determine the best time to liquidate a cryptocurrency portfolio? Or if a Chapter 11 debtor proposes to liquidate its cryptocurrency to fund a Chapter 11 plan, when does the debtor make that call? A 24-hour spread could be the difference between a full recovery for unsecured creditors or nothing at all on some particularly volatile days. And in the meantime, how does a trustee or Chapter 11 debtor ensure that the assets are protected from cyber theft? Staff for the U.S. Trustee Program, which operates under the Department of Justice, have published some initial guidance titled Investigating the Financial Affairs of a Debtor Who Has Cryptocurrency. While this is a positive development, the guidance is fairly cursory. For example, it encourages trustees overseeing estates with crypto assets to freeze the wallets of their debtors, but leaves most questions applicable to exchange bankruptcies unanswered. It remains to be seen whether the U.S. Trustee Program will issue more comprehensive guidance. The recent liquidation of Mt. Gox illustrates how crypto liquidations can defy expectations. Mt. Gox was one of the first major crypto exchanges. Following a cyber attack, it eventually collapsed in 2014 and ended up in a court-supervised liquidation in Japan. All this time, the court has been holding 140,000 Bitcoin pending case resolution. As of this past month, it appears that the administrator will stagger the sale of Bitcoin to satisfy claims in order to avoid flooding the market and further eroding the value of Bitcoin. If successful, this approach could become a model for future liquidation strategies. Next slide. In the later stages of a bankruptcy proceeding, the bankruptcy trustee will seek to return additional assets and value to the bankruptcy estate via avoidance actions, sometimes called clawbacks. The most common of these actions are to avoid preferences and fraudulent transfers. A preference is a transfer from a debtor to a creditor within 90 days of the bankruptcy filing. The Bankruptcy Code allows trustees to sue recipients of these transfers because it promotes equality among creditors. Put simply, it prevents a debtor from preferring one creditor over another. Various defenses are available to creditors, including those commonly referred to as ordinary course and subsequent new value. Earlier, I discussed that a customer of a crypto exchange, in most cases, doesn't really own the crypto, but rather has a right to payment from the crypto exchange. In other words, the customer is a creditor of the exchange. By extension, if a customer withdraws its holdings within 90 days of a bankruptcy, there may be a basis for a trustee to allege that a preference has occurred. How would a customer defend against a preference demand in these circumstances? For one, it could challenge the presumption of insolvency. Perhaps the exchange was flush with cash at the time of the transfer, but the events leading to the filing occurred suddenly. Or some commentators have pointed to Section 546E of the Bankruptcy Code, which contains a safe harbor provision for securities transfers through financial intermediaries, and argue that this could provide a defense for avoidance actions relating to crypto withdrawals if the cryptocurrency was determined to be a security. The other main category of avoidance action is fraudulent transfer actions. These include actual fraud, transfers made to hinder, delay, or defraud creditors, as well as the more common scenario of constructive fraud, transfers made for less than reasonably equivalent value while the debtor was insolvent. In the CRED bankruptcy, the liquidation trust filed a fraudulent transfer suit against a cryptocurrency whale. The trust alleged on July 2nd, 2020, while insolvent and nearing bankruptcy, CRED transferred 516 some Bitcoin worth more than $21 million today to the defendant in exchange for a worthless bond. In doing so, CRED deliberately ensured that the high-profile cryptocurrency investor defendant profited, while thousands of CRED's retail customers lost everything. In the coming months and years, we can expect this body of law to develop significantly as bankruptcy courts attempt to create order out of chaos. And now I will turn the mic back over to my colleague, Joe Liniak.
Thank you, Aaron. And now we're going to look forward as to what is going to happen, in particular, what's going to happen with the federal government, with a focus on the Biden administration issuing an executive order 14067. It may be referred to as the Empire Strikes Back, because up until now we've had the peripheral agencies, in somewhat technical terms, making allegations, and yet in March, when this was open, and again with an emphasis on a central bank digital currency, the Biden administration said, let's try to figure this thing out, and made a couple of directions and obligations on the federal agencies, and there are quite several of them, to look at the implications of a central bank digital currency, the design choices, what that means for economic stability, whether or not it should be done in the context of the government doing it or private sector administering a digital asset such as the banks, the extent to which foreign central bank digital currencies could displace existing currencies and alter the payment system to undermine U.S. financial centrality, and national security and financial crimes. What does it mean? What do we need to do about it in order to protect that? And there's some common themes here that you're going to see repeated now as the agencies weigh in. Also, the executive order indicated that draft reports have got to be issued by the agencies, addressing all of these points: the implication of developments of digital assets, recommendations that they need to make, both in terms of regulations and statutes. What about technological infrastructure? Can we even do this now? And just to digress for a moment, one of the things that's come out about this is that down the line is something you may want to take a look at if you're a bank, and that's called quantum computing, because someone has pointed out that you may have very, very highly complex passwords in your digital wallets, but quantum computing will probably be able to break that within several seconds. And so we not only got to worry about that in terms of just general banking, but in terms of digital wallets, that's something again. And then finally, law enforcement. What do we need to do here? That's a real concern. And there are proponents in the government that believe that digital currency is one or two steps removed from Tony Soprano. And frankly, there's a lot of evidence that that is the case, and this is not going to go away. How that gets solved is a difficult issue. The Treasury in July reached out and said, okay, we've got this executive order now. What do we need to do? And just basically laid it out there, because that happens very often with the government saying, hey, what should we do? What should we do in terms of adopting a digital currency? What are the opportunities and benefits to consumers and investors? What are the risks to financial markets, and so forth? And that is certainly in process. What I want to point out to you is that in that comment, they indicated a lot of things which are difficult to deal with in terms of cryptocurrency. The prevalence of frauds and scams, losses due to theft, losses due to private keys. And that happens very, very often. The moment you put your private key on an exchange, the scallywags can figure out a way to get it, or they can scam you into giving it to them. The failure of insolvency of wallets, custodians, and other intermediaries, which Aaron was just discussing, the authenticity of digital assets, and the impact on the most vulnerable, and how do we deal with protections to investors and consumers. One of the things which I would recommend that you may want to take a look at, which is actually very, very thoughtful, is a Treasury pronouncement on the future of money and payments. And I think that this is where we are going to go. I think the Treasury is signaling that this is what we need to do. And the first thing is we need to advance the idea of a CBDC if one is determined to be in a national interest. It's not clear yet as to whether or not it is, and we'll talk about that in a moment. encourage the use of instant payment systems, which are already online, such as Zelle, which allows you to do person-to-person transfers, an establishment of a federal framework for payment regulation to protect users, and cross-border payments. Now, this is one area where actually digital currencies and blockchain may be very, very helpful, but it's one of the few areas where somebody can point out and say, this is really where this is really useful. Then Treasury also, the enforcement folks came out with a report, an action plan to address illicit financing risks. And they likened it to a national risk assessment, talking about money laundering, proliferation financing, terrorist financing, discussing issues such as gaps in money laundering regimes across borders, the anonymity issues, because there are now a number of exchanges which mix up currencies together, so it's difficult to trace. And in fact, OFAC came out and sanctioned one of these entities, and they're now being sued about it because allegedly they can't prevent AML crimes from occurring if you use what is effectively could be deemed to be an application as opposed to an exchange. Disintermediation, again, good things to look at, very much a concern to the law enforcement folks. Another very, very useful document to look at is the implications to consumers, investors, and businesses. These are you folks out there, or maybe your teenage sons and daughters that are buying crypto, buying NFTs, and how do we protect them? How do we protect them against false and misleading advertising, terms of service, claims for return of potential income, and push a button, you're going to make a lot of money, and then you can sell your house and buy a bigger boat. Those types of things, and cross-agency enforcement actions which need to be addressed. And what they also talk about is individual enforcement actions, enforcement by regulation, providing clear language guidance, which I've never really thought makes a lot of sense. You got to describe it, and sometimes you've got to use English words that have got more than 4 letters to them. But then the Department of Justice, they rolled in as well in terms of law enforcement. And they talked about cryptocurrencies can be used to facilitate criminal activity, to conceal illicit financial activity, and basically to be used as a tool in the in criminal enterprises. And they've got a laundry list because they were given the opportunity under the executive order to give the government a wish list of some of the things they need to do or would like to do. A tip-off provision, increasing the enforceability of money transmitter businesses, forfeiture authority for people that are engaged in illegal activities used in crypto, and generally maybe building more crypto prisons for people, because some of these guys are really not necessarily nice folks. Let's turn for a moment to the specific provisions that directly affect bank regulation. The former OCC comptroller issued several interpretive letters from October 20th to October 21st, and they said, and that letter said, a national bank may hold reserves to support stablecoins. Oh, really? Okay, what about the risk there? They may provide cryptocurrency custodial services. Oh, that's a nice idea. What happens if you've got it in your wallet and it gets stolen? And may validate, store, and record payment transactions in the crypto universe. Well, these were pretty liberal approaches until we get to 21, when November 21, when the new comptroller gets appointed. He's now the acting comptroller, and he said, whoa, hold it. Yeah, that's true, but you can't do it until after we tell you it's okay to do. In other words, you've got to write us and you have to say, we want to engage in these activities, but you have to get our approval. And what they did, which was very interesting, is they linked it to the fact that if you do not have effective policies and procedures, engaging in these activities is not engaging in the business of banking. And that is about as extreme statement as you can get. And so in other words, if you're thinking about getting into crypto, you better call your friendly neighborhood regulator before you go ahead and do it. And then the FDIC likewise did something, and they requested, which is another way of saying they ordered, that what you need to do is have a sound risk analysis, and you have to tell us about it. And it's not only limited to state chartered banks, it's extended to anybody that's got FDIC insurance. Again, pretty important stuff. Before we run out of time, I just want to mention the fact that legislation is now beginning to start. And what the legislation, it's still in its initial stages. It's kind of important you track it because, again, this is going to go over several iterations. I frankly do not believe anything is going to happen maybe 2 or 3 years from now. But the wish list that some people have put together is that crypto is not a commodity, and Tom talked about that, and that exchanges should be regulated by the CFTC, and a whole list of things which limit the ability of the government to take action. We will see where that eventually comes out. A few observations, and you can take a look at this slide at your leisure about NFTs. Again, traditional laws apply to them, and you need to look at it. But a few observations, and then I'll turn it back over to Nick. One view is that as a result of the executive order, a federal central bank digital currency may mean that cryptocurrency could end up being a footnote in history. And that's there's a strong argument that we may already have or soon will have a digital currency. The Federal Reserve is coming out with the FedNow service. Most US dollars are already digitized in that those funds are resident on both secured in-house servers and cloud services systems, which are now protected. And frankly, the US government has signaled very clearly that it's not going to give up its central role of the US dollar as the leading global currency. And if you want to accommodate central bank digital currencies, it's going to be under the aegis of the federal government in a manner that preserves our economic security. Just a couple of other quick notes, just for and again, this may be in fun facts. Cryptocurrencies currently and blockchain are not able to handle the volume of transactions currently possessed by the US and global banking systems. They're actually very, very slow. And in terms of crimes continue to be rampant. And then finally, this is kind of a neat fact. Cryptocurrency doesn't work for consumer transactions. And that's because it's virtually impossible to be able to reverse them. And because of the ability to be able to reverse transactions when something happens, being able to apply a cryptocurrency transaction makes it very, very difficult to see how it's going to be applicable in the consumer market. So that is a lot of information. It's a lot of fun to be following, and we would certainly look forward to speaking with many of you about our thoughts and yours in terms of moving this thing forward. I'll turn it back over to Nick.
Thanks, Joe, and thanks, Tom and Aaron, for that presentation, and thanks to our audience as well for your attendance and attention. Do remember to complete the attendance sheet and return it to attendance@dorsey.com. And as I've mentioned at the outset, if you have questions for our speakers, you can find their contact information in the materials, or feel free to reach out to your usual Dorsey contact. Our next Bank Counsel Roundtable is scheduled for October 25th. Please look out for the invitation, and we look forward to seeing you all then. Have a great rest of your day and evening. Thank you.